Mr. Clayton.
Good morning, my lady, my lords. First of all, may I thank you for starting late. May I also, somehow this morning, which has been testing in more ways than I would have chosen, I seem to have lost my wig at some point. I'm not sure whether I've left it at home or I've left it somewhere else. So I hope you'll forgive me.
That's fine. And how are you on the computer? Have you now got one that works?
I have one that works, but and I have opened it, but I'm afraid it's the same make, but I'm not as adept at. Not that I'm particularly brilliant, but I may be a bit slow. And the thing which is quite important, and this may actually speed things up, is I have lost most of the references, like all the references to all the bundles.
What a morning.
What a morning, especially since I started at 4:30 with the hope I could sort it all out. Anyways, such is life. So I apologize profusely, but I have made fairly copious notes of the submissions I'm going to make, so I'm going to work from that. And I will give where I can references, and I hope that will be sufficient.
Those of us who are dinosaurs are pleased to find that hard copy is working well.
Well, that is my invariable experience, I'm afraid, but we've all moved on, sadly. Can I begin by, well, you'll know, but I appear for the appellants. My learned friend, Mr. Hopkins, King's Counsel, appears for the respondent. Our appeal is based on 5 submissions, which I will summarize in a moment. Before I do that, I want to briefly identify the salient facts which are pertinent to the submissions. The first is that I'm going to refer to the claimants by C1, C2, etc. C2 and C3 were involved in an accident on the 2nd of October 2016. And on the 21st of January of 2019, C2's claim was settled. C3's claim seems to have been settled on the 5th of October 2017. The position is that the C1's claim remains alive, so to speak, but there's been no determination on the question of fundamental dishonesty. And that affects the submission in this way, in our submission. The position before the judge is that this is not a case where there had been any determination of dishonesty and not entitled to proceed, obviously, on the basis that it's been proved that C1, 2, 3 have been proved to be fundamentally dishonest. Of course, that had that been the position, I accept that that would have been a completely different case, but it's not this case. The next point I want to briefly explain, but I'm sure this is obvious to you all, is how the judge described JS1, which is a witness statement prepared by Mr. Stevens, and it's described by the judge in her judgment at paragraph 12 as a spreadsheet with a lineup for each of the claims analyzed and the data set out under headings that include the name of the claimant, whether they were under 16, dates of any medical examinations, whether there had been a referral to a psychologist, and if so, the diagnosis and prognosis. Information entered in the spreadsheet was not redacted or subject to any form of pseudonymization. So I may trip over that word. The next point I wanted to make is about the order of His Honour Judge Backhouse made, it arose out of the hearing of the 20th and 21st of March 2023, and the order appears to have been made, is dated the 20th of March. And there are 2 elements of the order I want to draw attention to. On the first page of the order, which is in a supplementary bundle, page 220, the claimant solicitors gave an undertaking not to make any further application to debar the defendant or other insurer from relying on the witness statement of Mr. Stevens containing similar fact evidence. I want to come back to that undertaking a little bit later, not pretty soon, really. The second, which is important, is that in paragraph 4 of His Honour Judge Backhouse's order, the defendant was ordered to serve an updated version of the spreadsheets with the names removed. In other words, it was pseudonymized. Pursuant to that order...
And that is the position now.
That is
the schedule has pseudonyms in it.
That's right. And I also want to mention that there's been an order, which for some reason wasn't picked up in the judgment, but was made before the hearing. On the 23rd of October 2010, Her Honour Judge Bloom.
Do you mean 2010?
Do I mean 2010?
Possibly not.
I said the 23rd of October 2024. I'm so
24,
sorry.
you said then.
I should say I'm dyslexic to the extent that I have a very irritating habit of juxtaposing numbers. So thank you for correcting me. However, on that date, and it appears in supplementary bed bundle, page 287288, she ordered 2 further pseudonymizations. So there were 7 as at the date of the hearing. I now want to summarize our 5 submissions, which are these. First, the learned judge failed to apply the proportionality in accordance with Lumsden. In particular, the court was required to decide whether the respondent established that its objectives could not be attained by means of a less restrictive scheme. At no stage did the learned judge either expressly refer to or expressly assess the least restrictive means. And in our submission, that's a clear error of law. Secondly, really paraphrasing, in fact, what Lord Justice Newey said in granting permission, since the date was synonymized by virtue of His Honour Judge Backhouse's order and also Her Honour Judge Bloom's order, it should have been synonymized by the judge. We say that follows. Accordingly, we submit that the respondent disproportionately interfered with the appellant's personal data by permitting the respondent to proceed in these other proceedings by reference to their names rather than by some other means of anonymizing them.
Sorry, can I just understand that submission? The judge, there was disproportionate interference in what way?
By allowing the names to be identified, or perhaps a better way of putting it is by refusing to make this anonymization order. I think it's a better way of putting it. As I understand it, there are other proceedings afoot. I'll come back to that.
The order that was sought in this claim was a declaratory order.
Yes.
And an order prohibiting the use of the names in any other way. But that doesn't have anything to bite on, does it? Because there's been pseudonymization already. One of the questions in my mind, and I'm not saying you need to address it at this point,
Yes.
is what this is all for.
Okay. Well, that isn't.
I mean, it seems to me
Yes.
that you need to explain why it is that if the judge had got to the conclusion that what had happened in the past was wrong, that led to any form of order at the end of the proceedings, given what had already happened.
Right. Well, may I say, that isn't the view taken by clients. Now, that doesn't mean that the view they take is right, I accept. I mean, I wonder whether I should look at the order. Can we...
No, I didn't want to take you out of your
No, you haven't. But I mean, it's obviously quite...
Just want to raise the point. Perhaps it may be better if you summarise your 5 points and then come back to this when it
Okay.
arises.
Yeah, well,
Just before you continue, I mean, I would like to know whether this does matter. I mean, have you asked the insurers whether there's any question of them using a non-pseudonymized version in any proceedings?
What's the answer?
They have pseudonymized versions of new statements in many other cases apart from this.
They haven't.
We haven't received updated statements with pseudonymized.
So the position apparently is this. I'm not sure whether this is the position. Anyways. My solicitors haven't received any pseudonymized versions of statements in any other case. I think that's what's provoked the proceedings. And
But have they received non-pseudonymized versions? Or a threat to use non-pseudonymized?
well, they were initially. I think. Have you received any new ones or not?
We've received 7 updated with pseudonymization.
But no, that's not my question. 100. So what happened in respect to those?
They're still there.
been updated?
Look, I think the position, and it's not a very satisfactory answer, but it's not a very factory, is that there's nothing, the numerous proceedings where statements have been served remain in their initial state, which is to say there are still names on them. That's my understanding.
So to be clear, there are pending personal injury claims.
Yes.
Mr. Stevens' statement was put in all the personal injury claims.
Yes.
Thus far, orders have been made in relation to, did you say 7 of those
Yes.
sets of proceedings? So one then thinks, well, are the insurers insisting on using a non-pseudonymized version in the other proceedings? I mean, perhaps we should just ask
I
Mr.
thought
Hopkins
it
what
was
his
a
position
test
is.
claim, so it was
Well,
only matter in the test claim.
I think this is what's happened, which may not be an entirely satisfactory answer, but I think what's happened has been, in effect, a standoff, as the defendant's position they have not served pseudonymized statements consequent to the judgment of the learned judge. If I'm wrong about that, I'd be grateful to be corrected, but that's what I've just been told.
Should we just hear Mr. Hopkins on this limited point?
Grateful, my lord. The position is that the backhouse order, as you've heard it referred to, which contains provision for the service of the pseudonymized version of JS1, that applies to all claims in the RTA proceedings. I can help you later on with why I say that, but it applies across the board. As recorded in the judgment under appeal of Mrs. Justice Eady, first she says it applies to all future claims. She also records as a fact that the pseudonymized version has been served by my clients in the course of the RTA proceedings. So we've complied with that. The reason that there has been limited progress in terms of serving the pseudonymized version in other strands of the RTA proceedings is because they've been snarled up by endless appeals of the kinds that we're here today dealing with. We are, I'm told the RTA proceedings via the lead claim are coming on for trial before His Honour Judge Saunders in October. But the position, we say, is that as from the date of the backhouse order, and there we're in March 2023, it's only been the pseudonymized version of the JS1 spreadsheet that we have adduced that we propose to rely on. The why are we here question, I say with respect, is a very good one. If there were any lack of clarity about it, one would think Sam could simply write a letter saying, by the way, can we just make sure it's always the pseudonymized?
Well, with respect, I accept there appears to be an issue, and it may be necessary to look at the order, as to whether this is a completely academic exercise or not. But assuming there was a declaration made and there was orders made, one would have expected some confirmation about where we lay. I mean, perhaps we ought to look at the order, because it's not something I'm afraid I've studied.
I mean, just before we do, we've been told by Mr. Hopkins what his client's position is. So why are we here? I mean, they accept they're going to use a pseudonymized version. You say they should have used a pseudonymized version. So what's the point?
Well, I think the point... Well, firstly, I don't accept at all that this is can be explained away by the fact that there's litigation. There's absolutely no harm, especially since actually you would have thought it might be sensible for people to put their cards on the table. If there's been a silence, which there appears to have been, indeed, I mean, it's worth pointing out the sort of positions that have been taken here. One of the things, which I was going to deal with in a minute, is this so-called undertaking was said to undermine the proceedings altogether, which is, with respect, is not a good submission, but that's a different point. But it's difficult to understand why that submission would be advanced if the respondent's case is, there's nothing to this because we're going to obey it anyway. So I think, to some extent, this may be a case where the parties have got locked in their respective positions. But I would have thought that it would be incumbent on the respondent, defendants, if they were going to proceed with only synonymized witness statements of Mr. Stevens, that it would be incumbent on them to say so. It's also likewise incumbent on them not to advance submissions like there was an undertaking against it, or even more remarkably, when we look at it in a minute, that the issue of synonymization was never raised on the pleadings. I mean, what on earth is the point of saying that if your case is, well, this is all done and dusted? There's no point to it. So I think there's been an element from, at best, both sides about taking intractable positions. Certainly my submission in respect of the undertaking point and the point that it wasn't properly pleaded should never have been raised if the real point was that there's nothing in it. And I think this is right. Lord Justice Newey, when he granted permission, wasn't confronted with that particular point fairly and squarely. It's a very simple point for the defendants to have made clear, and they've muddied the water somewhat.
I am still confused. It's not usual to use the Court of Appeal's sledgehammer to get to the bottom of a standoff or a silence. And if in fact there is nothing in this and a great deal of energy and ingenuity has been spent in order to put together the arguments before us, it does seem nevertheless to be rather a waste of everyone's time, in the sense of what is it that is intended that should be achieved, and if that is that only schedules with pseudonyms shall be used, it doesn't seem, so far as I can see, that there is a dispute about that. And I wonder whether everybody has been proceeding under an enormous misunderstanding. Perhaps I'm being too simple about it.
No, with respect, my lady, there's sort of force to that. But what I would simply say, the first point I would simply say is, if that is I mean, even I could have drafted a response to a notice of appeal, and I would say, there's nothing in this. We're going to do this. It's a load of nonsense. But that wasn't what was said. That wasn't what was said. So,
well, I wonder whether costs are an issue, because so often our positions are driven by costs. If we were to conclude there's no point to all this, then there would be an argument about costs. So people sometimes make these points about the merits because they know that the allocation of costs will hang on it.
Well, with respect, I perfectly understand that. Indeed, I've come across it. But my answer to that would be, you don't fight cases because of costs. It's one way of running up unnecessary legal fees, which one sees far too commonly in the High Court and beyond it, and the appellate courts. And I'm sorry to be a bit boring, but I would respectfully say that if one was met by in-principle objections and with an absence of any documents served, which are synonymized, then that doesn't help. I mean, maybe one solution. May I make the suggestion just before? I'm sorry, I do apologize for it. I mean, if you took the view, and I'm not inviting you to do this, but if you took the view that actually this case really was of academic significance only, then given the stance of both parties, it would have to be no order of costs for anyone.
And I dare say the respondents wouldn't take that view. So having set this hair running, perhaps it's better, Mr. Clayton, if we allow you to resume your 5 points, and then we could hear from Mr. Hopkins generally in due course.
Right, okay. I mean, I'm perfectly happy to do that, first of all. Secondly, I mean, do you want me to stop short after making my submissions, or do you want, I'm not quite clear what the court would prefer me to do.
I think make your submissions.
All of them?
Yes.
All right, thank you. Thank you very much. Okay.
Mr. Clifton, I had your first 2 points.
Yes.
I think that's where we were.
Thank you so much. Can I just... here we are. Our submission is that the learned judge, this is the third submission, erred in law in failing to hold that the respondent had disproportionately interfered with the appellant's personal data by permitting that personal data to be used in the third-party proceedings, the proceedings which they were not part of. The fourth submission is this. Since the appellant's submission in respect of the backhouse order for synonymization was the appellant's central submission made to the learned judge, it is remarkable, with respect, that she failed to address that submission or explain why she rejected that submission in respect of proportionality. What makes it even odder is that it is considered in two other contexts, which I'll come back to in a sec, but it's not considered in respect of proportionality, and that was the place at which it should have been. And the fifth submission is that, as Lumsden requires, in the circumstances before us, we would invite the Court of Appeal to reconsider the case and to apply proportionality on the proper basis, which is the very language from Lumsden. Can I next move on, which to some extent I've preempted, but I want to just deal with a few submissions which are in our submissions have no force. Sorry. The first is, and this is with respect a difficult submission to understand, the submission that the undertaking in the backhouse order prevented the appellant from making a claim under the Data Protection Act. With respect, it obviously doesn't, and I don't know why that's suggested. And it's also, to make the point in a slightly different context, it's also very difficult to understand why you'd say that. If you say, well, there's really pointless.
What specific passage are you?
It's going to be, if you give, it's in the central, it's in the core bundle, and it's page 110. So let me just find the core bundle. I haven't opened these yet, so I watch with trepidation to see what happens.
This is in the defence. Why are we concerned with the defence at this stage?
Oh, sorry, have I got that wrong? I thought it was page 100. Is it the core bundle? I'm so sorry. Is that my? See, I haven't been able to check any of these that I would have done. It's in the backhouse order. I'm not quite
But sorry, no. But which submission are you saying is ill-founded?
The submission is, it's a reference to the backhouse order.
And where is the submission to be found?
The submission itself?
Yes.
Wait a second. I think it's from memory, because that disappeared overnight. I think it's paragraph 3 of the respondent skeleton. If that's correct. It's from memory.
Well, they say that these data protection claims are in substance an attempt to circumvent the determination. That's not alleging a breach of the undertaking.
Well, what exactly is it?
I mean,
all right,
since that doesn't seem to be the point, let's move on.
Okay, fine. But in any event, it doesn't seem to take us anywhere. The next point which is raised, which I think is at paragraph 6 of the skeleton, is that pseudonymization is not mentioned in the appellant's pleaded case. And that, with respect, is just wrong. If you look at the amended pleadings, which appear at the core bundle, page 101, that's the first time very clear. It's paragraphs 13.3 and 13.4. I hope I've given the correct reference. Did I say it was a core bundle? So sorry. Yes.
Well, the judge held that this wasn't sufficiently pleaded.
Well,
May or may not have been a ground of decision, but she did make that.
but she also decided that all I'm suggesting is, in fact, was pleaded. It perhaps doesn't matter very much because she went on to decide she could consider the issue anyway. So that seems to be, if I may say so, a somewhat academic submission. What point does it serve to say that? When the judges decided that she had...
But it's not a ground of appeal that she was wrong about that.
No,
although you fairly say, well, it doesn't matter.
But it
I'm not sure why we're being told that she was wrong about it when it's not a ground of appeal.
No.
A ground of appeal is about proportionality.
I understand that. All I'm saying, though, is that point which is made, leaving aside the fact the judge decided it didn't arise, and indeed Lord Justice Newey, in granting permission, made the same point, it actually was pleaded. So it's just difficult to know what on earth's been said. That's all. And it's pleaded in another point.
Sorry, where is it pleaded?
So sorry. If you look at, forgive me, page 101.
Yep.
Sorry, where's it gone? I'm struggling with my... 101. Nothing's happened with my new computer. Well, it is at 101, unless I've corrected.
Well, the word pseudonymization, according to my word search, doesn't appear there. This was really the way the judge approached it. She said the rules say that you've got to make it clear what you're complaining about, and it wasn't sufficiently done. But then, as you point out, she didn't dismiss the claim on the basis it wasn't pleaded. She went on to address the merits.
Yes. Well, let's move on. Again, it seems to be a forensic point rather than one that, and certainly there's no cross appeal that she acted wrongly in the exercise of discretion in doing that. And then the next point, and this is one I wanted to return to. I said this already, is that the judge discussed Article 25, which is the article which is relevant to pseudonymization, in actually two different contexts. In paragraph 102, in relation to fairness, and in paragraph 108, in relation to data minimization, storage, limitation, integrity, and confidentiality. With respect, however, she didn't mention it at all in the discussion of proportionality. It's not clear to me why that is, but she chose not to.
Sorry, I'm being a bit slow. What did she mention in those two paragraphs?
She dealt in one. She mentions that 101, that synonymization would be a potentially relevant means of complying with data minimization, storage, and limitation, etc. That's 101. Sorry, is that right? 101?
I think you told us paragraph 102, but
I'm sorry, right. I did 102. I'm so sorry, it is.
that's fine.
That was in respect of fairness. And then at 108, she dealt with it in a different context. That was fairness. And then at 108 in a different context, which is data minimization. It certainly appears there as well, in both instances. And really, the submission I make about its omission is that since it was a central submission for proportionality too, that is, in our submission, a problem.
I'm not sure I do follow, I'm afraid. I mean, the judge has identified the real focus of your case is absence of pseudonymization. So that runs through what she says, doesn't it?
Well, I will look at the judgment specifically on proportionality, but the point I want to flag up is the one subject it doesn't raise is pseudonymization. It just doesn't cover it. I'll make criticisms of the paragraphs that are in the judgment, but I want to make it clear that it doesn't figure there. And what is slightly odd in our submission is that it is covered in other topics. That's my point. Now, dealing with Lumsden, and can I say, I'm afraid I haven't had time to take a note, this is also relevant to, there's a judgment of the Court of Appeal, which is, where the judgment is given by Lord Justice Sales, as he then was, in 2019. And I'm going to suggest that it's difficult to understand why, but that judgment doesn't refer to Lumsden at all, nor to South Lanarkshire, which is the Authority 2013 Lady Hale judgment. And that, with respect, in our submission, can't be stand. I mean, it's also worth noting that in Lumsden, the judgment was given by Lords Reid and Toulson, but Lady Hale was a party to the Lumsden judgment. And it makes it somewhat odd that reliance was made in 2019 on the earlier cases without any reference to Lumsden at all.
Is this the position that Cooper was decided without reference to Lumsden, and Lumsden was decided without reference to South Lanarkshire or Cooper?
Yes. Yeah. But there is an explanation for that, which, because I'm going to take you very quickly through the sorts of propositions that come from. I mean, I think the simple answer is that the ECJ, if I can call it that, had moved on. If we, I have derived, I haven't got the paragraphs, forgive me, but Lumsden, as you will remember, is about, forgive me, it's about the consideration of an approval scheme for advocates. And the first point I make, which I think is, as appears in the headnote, may explain the omission of the South Lanarkshire and Cooper decisions, is it stated by the Supreme Court that the only authoritative interpreter of EU proportionality is the Court of Justice. And clearly they looked at a whole lot of other cases in the Supreme Court. They also say that the approach to be taken must be nuanced and fact-sensitive, and that the way the principles have to be applied depends significantly on context. And then also say, paragraph 108, which is quoted in the skeleton, that if the courts below err in their approach to the principle of proportionality, the case has to be reconsidered. And in this case, we would submit has to be reconsidered by the Court of Appeal on a proper basis. The next point, so far as it's relevant, it's not clear to me whether or not it is, it's obvious, say the Supreme Court, this is at paragraph 26 of their judgment, that EU proportionality is different from European Convention proportionality, which of course we're all familiar with. They say, the Supreme Court at paragraphs 33, 34, that the EU proportionality involves the consideration of two questions. First, whether a measure in question is suitable or appropriate to achieve the objective pursued. And secondly, whether the measure is necessary to achieve that objective or whether it could be attained by a less onerous method. That's the focal point of our case. They then deal with national measures the Supreme Court at paragraph 73 and following. But I think in this case, as I understand it, it's common ground that the Court of Appeal, that the learned judge should apply the proportionality test. And we would submit that the question in line with Lumsden is whether there is a less intrusive measure could have been used without unacceptably compromising the objective data protection in this case, which the courts need to consider. And that formulation comes from paragraph 105 of
you say, you use the term common ground. As I understand it, it was common ground in this case that the test the judge applied was the right test.
Well,
so you're implicitly criticising counsel who appeared and the solicitors who still instruct you for failing to take the right legal point, and criticising the judge for saying the judge was wrong to accept a proposition of law that was common ground between the parties. So this is a new point being taken on appeal, accusing the judge of being wrong for accepting a submission that your client made, which is not common and does attract some rules about whether you're allowed to run these points.
Well,
the fact you've got permission doesn't foreclose that.
No, I understand.
I think that's got to be dealt with at some point.
I understand that too, but my answer, with respect, I think your lordship has answered one of the puzzles that I've found in this case. But whatever the position was, it is frankly well known that the authoritative statement of proportionality was Lumsden. I mean, it may be that, as in the 2019 case, that, and this I'm afraid does happen in the modern world, is that people are so used to arguing their specific corners of law that important cases of principle get left behind. But we would respectfully submit that Lumsden is the key case on proportionality.
Well, I certainly can't imagine that Lord Justice Sales would not have known about Lumsden.
Well, the thing which is odd about, I can't tell, but if you read the judgment, there's no reference to it at all.
But this was his specialist area. He would have known about the law of proportionality.
Well, my lord, I won't. Let me put it this way: there are judges. I'll deal with it this way. There are judges who will say, when one speaks to them, actually, I don't remember any of the cases other than as soon as I've done them. So, and of course, Lord Sales wasn't in Lumsden because it predated his period of time in the Supreme Court. But one can certainly say this from experience of appearing quite often in front of Lord Sales. If Lord Sales knows there's a point which he wants to hear about, he's not slow about saying that. That's the best answer I can give. I mean, it's a puzzling situation, at least to those people who are familiar with EU proportionality, that the leading case, and the Supreme Court case as well, is not referred to or discussed. And our submission would be that it would be very unsatisfactory for that omission to have the effective meaning that a case which failed to mention it nonetheless stood. But the more so, actually, for what it's worth, because of for what it's worth, the judgment of Mrs. Justice Eadie is being reported. So it's obviously going to be regarded as authority in other cases.
Well, she was following authority in the Supreme Court and the Court of Appeal on what the meaning of necessary is
Yes.
in the data protection legislation. Lumsden isn't authority on that proposition.
I accept that. And if the position is, which hasn't been argued so far at any rate, that the statements of Lumsden don't apply to the area of data protection, that requires a certain amount of debate. Certainly isn't a self-evident truth.
No, I agree with that. It's a point that occurred to me that a reconciliation, which isn't the one that you've offered, is that those two principles are not inconsistent with one another.
Well, if we get into that territory, it then becomes necessary to look at what is said in Lumsden around paragraph 73 onwards, which is all the discussion about what Lumsden does is it says there are three kinds of cases, and the third category of case is where it's said that a domestic court has failed to apply proportionality properly. And certainly looking at that discussion, which is about 5 or 6 paragraphs, there's nothing there which suggests that the general rule isn't. What the case in Lumsden was really about was at least focused on, was about whether it was a rationality test or a more intrusive test. That was the principal thrust of the case. But they do discuss the 3 different contexts in which the issues arise, and there's very little comfort there.
And I've just stood back from this and sort of looked at the facts. The facts are that a document was put in as part of a piece of litigation with a view to being relied on to advance a proposition.
Yes.
Your argument is that unless the personal data in that document were minimised to the absolute minimum possible,
Yes.
there's liability under the data protection regime.
Yes, and I'll make that good.
Yeah.
But
It's quite startling.
well, with respect, I'm going to suggest it isn't that startling at all. I'll make that. I'll address that at a later stage when I go to the reasons the judge gives for her conclusions. But I accept my lordship's point that it may require justification. But can I also make this general point at this stage? It would be a very unsatisfactory situation if different areas of laws were sort of tribalized by having different tests in different areas. In our submission, a court would be slow to take that approach, because Lumsden does describe an overarching principle and does apply it in the very context, not with data protection conference, but in the very context of challenges to the proportionality of domestic measures under EU law. I mean, maybe, would it be helpful to go to that now?
Follow your own course, Mr. Clayton.
Well, I wonder, well, since we're looking at it, it might be sensible. Can you just give me a second, please? Sorry. It's obviously in the authorities bundle. And it's Bundle 8. And if you just bear with me, sorry, I had all this marked up, but it's kind of gone with the wind. From memory, it's around paragraph 73.
Are we in Lumsden?
Lumsden, yeah. No, I'm so sorry. I think the relevant passage begins with page 202, paragraph 50 onwards. There's an earlier passage where Lord Reid and Lord Tolson describe 3 categories, and the national measures derogating from fundamental freedoms appears to be the passage which is most relevant to us. Oh, I'm told to look at paragraph 35. Thank you so much. I'm grateful. Yeah, I've been asked to take you to paragraph 35. I see paragraph 34 has... Well, paragraphs 33, 34, and 35. I wonder if you could just read those, please. Oh, so sorry. Thank you for that. can
Yeah.
see, my friend has pointed out taken you to the wrong bit, which appears, it wasn't paragraph 50, that was the first category. I think my memory may have been wrong.
Yeah, I mean, I mean, just so you can deal with it, this is what prompted my thoughts. What the court is dealing with here. First of all, it says in 34 that case law applying the proportionality principle in one context cannot necessarily be treated as a reliable guide to how the principle will be applied in another context. And then it goes on to review 3 types of case, which are described in paragraph 35 and dealt with later, none of which is akin to the sort of case we're talking about here.
Well,
That's the way that I'm thinking. Just so you
I
know.
understand that. And before I take you to the bit, can I say that there is a difference between saying that the principles have to be applied differently, but that doesn't entail the proposition that the principle itself is different. You still have to use the same principle, which is the least restrictive means principle. That's my point. And I accept entirely your Lordship's point that it may play out differently in different contexts. And with respect, I entirely accept that. But that's not really the same thing. I'm not conceding that it's open to a court to simply ignore the least restrictive means test. Well, I was right. It was paragraph 73, which you pick up at page 207, 208. I just ask you to read 73 and 74 first, please. That's at 208, 73, 74.
And they're about directives.
Well, I may be wrong, but I took the context to be about the implementation. I mean, the reason why I said national measures, I was referring to, I mean, it is effectively retained EU law, but to the general data regulation, which are English.
Well, this would apply if one was talking about the Data Protection Directive and matters such as the discretionary approach to exemptions.
Right.
I could see that. But the GDPR was a regulation. It was a directly effective piece of legislation while it was part of our law.
That's the difficulty, isn't it? I mean, I'm not quite sure how you categorize it when it was part of our retained.
I think it's
EU
now
law.
called assimilated law, but it was at the time. It was at the time we're talking about. It was still. I'm not quite sure what its status was, but at any rate, it's not a directive which had to be implemented via domestic legislation in a way that was compliant with the EU principle of proportionality. It's really just a direct question of interpretation, isn't it?
Let's just take this in stages, if we may. With respect, I don't accept it's just a question of interpretation. But in fact, and maybe I've misunderstood this, for which I apologize, but as I've understood it, the regulations take effect as domestic law, and they aren't retained by the EU. They were basically continued as an independent legislative decision by Parliament. That's my understanding of it.
I think that's right.
So that being so, that's why I took us to this section. And if I could just, I'm not going to take very long over it, but the point I wanted to make, which comes up next, is the discussion of the Sinclair-Collins principle, which is basically whether there's a rationality test or a more intrusive test. And I can skip through that because it's rejected by the Supreme Court, but was the test used by the Court of Appeal in Lumsden itself. So I can take you through that. And sorry, I got it lost. So I'm handicapped by the fact I don't have any of my markings. But as I understood the conclusion that the Supreme Court reached was that the Sinclair-Collis principle did not apply, and that the ordinary principles did apply, and that included the least restrictive means test. And it importantly also means that the court is the body which has to make that decision.
So can I just understand, you're dealing with a piece of EU legislation, a regulation, which on the face of it you have to construe. So on your case, where exactly does this principle fit in?
Well, firstly, with respect, my lord, it isn't an EU. The position has been complicated by Brexit, but the position about the regulation, which is the one that I'm concerned about, is that that is an enactment by the English Parliament to give effect to EU law. So it's slightly different than simply saying it's retained the EU law. I mean, that was the position until...
Well, can we sort of stop the clock pre-Brexit for a moment?
All right, okay.
So how did it work pre-Brexit? You had a regulation.
Yeah.
You had to construe it.
Yes.
So where did this principle fit into the construing of the regulation?
Well, what this authority makes clear is that whenever one has to consider the proportionality of a measure...
Well, and why did you have to consider the proportionality of the measure rather than construing it?
Well, the first issue is the construction of the... What does the regulation cover? But it's accepted that, and it's accepted by everyone, and indeed the judge proceeded on this basis, that once you looked at the relevant articles, the number of different articles which you refer to, that was an issue of construction, their scope and ambit and so on. But once that exercise was done and it was decided whether they applied, it was still necessary to consider what was proportionate or necessary. And
Well, you find the word necessary in the legislation, don't you? Or am I misremembering that?
I'm not sure that's true, actually.
The word necessary appears in the GDPR provisions that were at the heart of the case.
Right, okay, I accept that. So the word necessary does, but again, in our submission, and this is the submission, is that the word necessary, it's difficult to see how the word necessary can exclude the obligation to consider objectively whether the least restrictive means has been applied. What does necessary mean in that?
No, I quite follow. There's a point about construction there, but you're not basing yourself on construction. You're saying that the overarching principle of proportionality comes into this. So I'm just trying to understand where it comes in.
Well, because for this reason, it's important not to get lost about the use of words. Necessary is used in the context of proportionality. It's generally understood as being part of proportionality. And as I submitted earlier, our submission is that the word necessary in the regulations does not exclude the general principle in Lumsden. Because that's what necessary, it's a part of what necessity involves. That's the submission. And I mean, the submission is neither more nor less than that. Is that essentially you have a principle which is established by Lumsden. That principle has to be applied in every case, albeit the way it's applied will differ depending upon context. But it would follow in our submission that no discussion of the least restrictive means is unlawful. It would make the decision wrong because it's contrary to Lumsden. That's the submission in a nutshell. Now, I have to say that the submissions which I will go on to make all assume the correctness of that central submission, because that's our submission to the court. And I do accept, if I may say so, the rebuke given earlier about the fact that I may have overstated it by accusing the judge of falling into error and by listening to counsel. That may be a slightly unfair way of putting it. But,
Well, the point was really this, that some of the cases in this court have revisited the question of when a decision at first instance can be said to be wrong,
yeah.
when the point being taken was not argued. But the answer, I think, is that if the outcome was wrong, then it can still be said that it was wrong, but we don't necessarily allow new points to be argued willy-nilly.
Indeed.
I mean, there are tests in the... We've got Singh and Das. There's Notting Hill Finance. The tests are quite well established. One of the tests, in some of the cases, is that the party taking the new point can meet the costs of the other side, consequent on that point succeeding if it does. And another is that there should be an explanation, usually, of why the point is being taken now and not before. At the moment, I don't know the answer to either of those points.
Well, I can give you
a
answers.
partial answer to the second one, which is oversight.
Pardon me?
Oversight, I think, was in a word the answer you gave to
yes.
why it wasn't taken.
Well, I mean, or to put the fairest way of putting it was new eyes looking at the case. That's the fairest way of putting it. And just dealing with the arguability, which is not one of the points raised, but that doesn't, of course, preclude the court from taking a different view, is in our submission, our answer, or at least one of the answers that we would give about whether the point should be taken is the magnitude of the legal error. And in our submission, it is a serious legal error for the leading case in the Supreme Court not to have been cited. And I'm not criticizing people, I want to say, but this happens. But nonetheless, it's a serious error in our submission.
And just before you move on, you've got the Cooper case, decision of the Court of Appeal. Normally we are bound by decisions of the Court of Appeal. Why aren't we bound by this one?
Well, can I just confirm, because I haven't had time this morning to refresh my... Is Cooper the Lord Justice Sales case?
Yes.
Yeah.
Thank you. Sorry. I'm afraid, and I say this with some hesitancy, but with respect, it does appear to be per incuriam, because one would have expected the leading case on the subject area to have been put before the judge, and for the judge to have the opportunity to say, well, I don't accept it applies in this context, or I do, but that didn't happen. I obviously hesitate, especially in respect of Lord Justice Sales, to make the suggestion, but in the end, which is really the point that's been made to me about this case, is one is bound by the cases that the counsel put before the court.
I mean, Mr. Coppell, Philip Coppell,
Yes,
was for the appellant in that case.
he was.
Yeah.
He's a former colleague of mine. I did
Yeah, so
Kennedy in the Supreme Court with him. I know him quite well. All I can say is, I don't particularly want to, I'm not in the business of criticizing people particularly, but I do make the point, which is that on the face of it, the failure to raise and get Lord Justice Sales riposte to Lumsden comes within the category of cases which is per incuriam. So that's the answer. I wonder, obviously, all the submissions I make at this time, at this point onwards, are premised on the Lumsden approach. And can I just find the judgment, which I think, I assume would be in the core bundle. Sorry, I've not looked at
Tab 5.
Yeah, sorry, I'm just, thank you so much. I've ended up, I want to start at paragraph 99 or thereabouts
Of the judgment.
of the judgment, yeah.
That's page 84 of the core one.
Thank you so much.
I think it might be in the
Oh, is it? Well, anyways, I'm looking, I'll just deal with it here, I think, if I may. No, I've gone too far. So I'm looking at the, I'm on page 80 of the core bundle, which is the learned judge's holdings in respect of proportionality.
Page 80.
Of the core,
Yes,
of the core bundle, yes. Yes.
Paragraph 90.
Paragraph 90 on
Paragraph 90. Thank you.
Sorry. The first point I'd make is the way she titles the debate, which is necessity and proportionality. They are the same thing. And that's the submission that I make. They're the same concept. If we could look at paragraph 91, which I'd ask you to read. She says, in order to determine proportionality, the first question must be, why was this done? The answer is provided in JS2, where he explains Mr. Stevens is unable to use the defendant's case management system because of the various complexities of the case. Given that he would have been provided the data to the solicitors who'd been instructed to act, he had already had the information to question Ursan's own claim. He took the view this was necessary and proportionate. The first thing to say is that on the face of it, the judge makes no independent view, as Lumsden requires, to consider for herself whether this is the least restrictive way of doing it. First. Secondly, there's no suggestions that Mr. Stevens considered pseudonomination, whatever the word is, can I call it pseudo for sorry? That process when he formulated this scheme. Thirdly, the judge makes no reference to pseudonymization, which is particularly with respect odd, given she does in relation to paragraphs 103 and 108 in different contexts. And since this was the core submission to the court, that necessity and proportionality required pseudonomination, that with respect is a conspicuous absence.
Well, she does refer to pseudonymizing names in paragraph 91.
So sorry, let me just
above the second hole punch.
So I've reproduced this on my notes, so if you just give me a moment to...
I mean, she does deal with this. She's accepting that another way of processing the information, pseudonymizing names, is subsequently deployed. I do not consider that means that the original presentation of data was not necessary.
Yeah, well, I just want to pull... So, I'm so sorry, you're absolutely right. That's my fault. But I'm going to step back and just ask this question. Why is a decisive issue the approach taken by Mr. Stevens, rather than, as it should have been, the court's view, independent view of what was the least restrictive means. That is simply not explained in that paragraph, or ever explained. Why, in a context when, and this is equally true of the convention proportionality as it is of EU proportionality, when the court is the final arbiter of proportionality, why does one defer entirely to Mr. Stevens?
Well, a possible answer is that she's not doing that. She's answering the question that she's posed, which is why was this done, which is the first of the two questions in the Lumsden proportionality test. Is it appropriate or, whether the measure in question is suitable or appropriate to achieve the objective pursued. So is that perhaps what she's doing in 91 before going on to...
That would be generous, but it may be that.
Yeah.
I accept it could be that. But that is, as, forgive me, my Lord Justice Newey's pointed out, I think it's the only context in which pseudo-nomination is referred to in the proportionality discussion.
Well, I mean, again, at the end of the paragraph, she's, without using the word, saying the same thing. She says, after the information had been filed with the court and served on Ursan, it was possible to agree an alternative way of presenting the data. Before that initial step, however, I am satisfied that the processing undertaken was necessary. So she's dealing with the point specifically, isn't she?
With respect, I don't accept that at all. I'm afraid I don't. In our respectful submission, it's the task that she has to consider is to make an independent assessment of the least restrictive means. It's, with respect, irrelevant that that wasn't something that Mr. Stevens considered at the stage that he did. That's actually allowing Mr. Stevens to substitute his view for that of the court, which in our submission is impermissible. I mean, it may be that...
And so what is she doing at the end of 91 when she says, I am satisfied that the processing undertaken in JS1 was necessary?
Well, if I may take that point, say that's why it doesn't look as if she's simply concerning herself with whether the aims were legitimate. She appears to have elided two different questions, question 1 with question 2, and answered question 2 by allowing the judgment of Mr. Stevens to be determinative of the answer to question 2. And with respect, that's not appropriate. I mean, that's just not Lumsden.
Should she have rejected all of Mr. Stevens' reasons for using the names as inadequate explanations, which meant that should she have concluded that he could and should have done this in a way which didn't use any of the names at all?
No. In my submission, what she should have done is said, this is what Mr. Stevens did. One understands that was what he did. But my task is a different one. My task is a task of assessing, as the court and the arbitrator of proportionality, whether the approach taken here amounted to the least restrictive means. And that's precisely what she never does.
But what's the answer to that question? I mean, you're saying your proposition has to be that she was wrong, the outcome was wrong.
Yeah.
And that there was a least restrictive means that fell short of using the names.
Well,
these reasons given by Mr. Stevens were not adequate reasons for taking the course that he did.
No, I'm not.
At some stage in the argument that has to be.
I'm so sorry. I'm not saying precisely that, because I want to look at the other paragraphs in a moment.
Yeah.
But what I am saying is really this, is that she appears to have conflated the two proportionality questions in that paragraph and deferred to the judgment of Mr. Stevens. That's my submission.
Yeah, understood. Thank you.
If we then go on to, let me just see where I've got to. Just to make some, I'll just make these points quickly. She basically, the judge, learned judge, gives no reasoning to underpin any rationale for holding that using individual names was proportionate. She does say that she's satisfied that the processing undertaken was necessary for the UK GDPR purposes, which appears on the face of it to be precisely the point I just made, without any independent assessment. So I make those points. If I then look at...
So just supposing that she's read Mr. Stevens' evidence, she finds it convincing as to the problems that were identified, and that's the basis of her decision. What more should she have said?
Well, at the very least, what she should have said, you can't, in our submission, you can't simply accept someone's reasons without a little bit of explanation. She simply failed to do that. She's failed in the judicial duty to give proper reasons, or adequate reasons. Can't just say, well, he thought it was okay, so that's what I'm deciding. No judge should do that. And indeed, there's lots of case law on that. She then turns at paragraph 92, where she says, I'm satisfied that processing an issue was both necessary for the legitimate objectives, and those objectives were not outweighed by the interests of fundamental freedoms and were necessary for the purposes of legitimate interests. Well, again, there's a complete absence of legal reasoning, complete absence of reasons at all. You can't state a conclusion without indicating the route by which you come to it.
Or does she not go on to give some reasons?
Well, I'm going to go, I promise I will look at all the paragraphs. She then, in paragraph 94, says...
What about 93? Is that not relevant?
Oh, I'm so sorry. Yes, it is. That's my fault. She said it's relevant that the processing related to data with a view to commencing personal injury claims, and talks about the primacy afforded to open justice that was disclosed in open court. But with respect, and this is the submission, the fact that someone launches proceedings in open court does not entail the proposition that disclosure after the proceedings have ended means that there's no reason to consider pseudonymization. It just doesn't have that effect. Otherwise, it would have, it's stated much too broadly, because it would mean that in any case where anyone brought proceedings, they couldn't subsequently claim in separate proceedings, which had nothing to do with them, that pseudonymization was the appropriate measure to take at the point of these other proceedings. Because... Well,
she's not really using this as a clincher, is she? I mean, the authorities suggest, I think, that if information is disclosed in public in the course of legal proceedings, it may be difficult to say there's a reasonable expectation that information won't be reused.
Well, that, with respect, is taken from a different area of the law. That's confidentiality. And I'm not saying it's unimportant, but it is different. And the point that I am making is that pseudonymization at the stage when the proceedings had ended isn't precluded by the fact that someone takes legal proceedings. Otherwise, if that were so, if that proposition were correct, it would mean that in any case where someone brought proceedings and that what was said in it was raised in subsequent proceedings by someone else, it would not be open to that person to say, well, actually, you shouldn't be using my name. You could pseudonymize it perfectly adequately. I mean, there is a point which I'm going to come to in a moment anyways, which is what on earth is the benefit achieved in naming people? There's none.
Well, it's a practical advantage. That's the reasoning of Mr. Stevens, that he wanted to achieve an objective and he couldn't do it for the reasons that he explained without using the names.
But that, with respect, was overtaken by events because 7 cases were pseudonymous.
Well, that was because eventually Ursan decided that they would use, it was more practical when it was decided, that Ursan's numbering system would be used in place of the names.
Yes.
So that's a different way of approaching the same problem, which wasn't open to Mr. Stevens because he didn't have Ursan's database of numbers.
Well, that, with respect, makes precisely the point I'm making, because the fact is that at the time the judge was considering it, that was the option open to her. That's precisely my point, because both synonymization orders had been made before her judgment. And the backhouse thing is actually mentioned in the judgment. For some reason, the Bloom is not, but the backhouse is. And one of the criticisms I make about using the Stevens material is it's just looking at the case too early on. The case had moved on, the issues had moved on by the time you get to the learned judge's decision, because at that stage, the initial proceedings had come to an end. And if you can identify the relevant, if you can identify the personal information by using a form of words which doesn't disclose names, with respect, that must be a less restrictive way of ordering how the case should be dealt with. And that's why I complain that synonymization doesn't really figure in the analysis.
So, just to understand, you're not seeking compensation, you're seeking a declaration.
Yeah.
So what should the judge have declared? That it became wrong not to pseudonymize from a certain date? Or what?
Well, she's not going to make a declaration in respect of anything earlier than what she was doing. She could have made a declaration that it is unlawful for personal data of the claimants to be disclosed unless their identity was pseudonymized. That's the declaration she could have made, and that would have been handy. And that she didn't do.
But the declarations that were actually sought in paragraph 55 of the amended particulars of claim were, first of all, that the defendant, in disclosing and using in the Mayor and City claim and other courts and other claims, the personal data in relation to the three claimants infringed Articles 5 and 7 of the GDPR. So it was a retrospective claim saying, among other things, you were wrong to do what you did. And that was the claim that the judge was trying.
Well,
so it seems puzzling to me that you say she shouldn't have looked back, because that's what she was being asked to do.
well, let's be clear about. To make a number of different points about that. The person who conducted the hearing, and I make no criticism of him at all, made a case on the basis of a debate as to whether it was pleaded at all, and the judge decided that didn't matter. And all I'm saying is this about the declaration, and if I express myself inelegantly, I apologize. When a judge or judges make declarations, they are to achieve the most efficacious solution to the problem that's been posed as possible. And the most efficacious declaration to make would be to this effect, that hereinafter, the identity of any claimant, of the three claimants, forgive me, C1, C2, C3, hereinafter, the identification of those three people could only be by means of pseudonymizing. I'm sorry, I keep on mispronouncing that.
Yeah. They have to be pseudonymized.
Yeah.
Well, their names must be used.
Their names mustn't be used. Yeah. That's all. And that, I mean, declarations, if I may say so, normally turn out to be quite straightforward at the end, despite the huge amount of ingenuity in devising some. But that, with respect, would have met the case.
I mean, just looking at the skeleton for trial, this ends up at page 91 of the supplemental bundle. The conclusion is that the claimants seek a declaration that the defendant interfered with their rights and compliance orders. So there's no suggestion at all that all we want is a declaration that from now on you can't use our data without pseudonymization.
I'm handicapped because my Lord Justice Warby referred to the order. I'm afraid it might be sensible to see the order the judge actually made.
Well, she wouldn't have made that order. I was just referring to the particulars of claim at page 106 of the core bundle. And this is only part of the remedies sought, of course. The declarations were in paragraph 55, and then there were compliance orders listed in paragraph 56, which obviously had to do with future, and they involved expunging various bits of information, and there were also injunctive orders, I think, sought. Orders for notification. Anyway, I mean, the point that I was putting to you, just for your response, was that the claim appears to have been, in part at least, one that looked back to what had happened in the past, seeking some sort of remedy to declare that that was wrong at the time, rather than just looking forward to govern future use of the data.
I accept that certainly what's in the skeleton is something which is attributable to the claimant. The pleadings were not done by him, so I accept that. But I don't resile from the proposition that the declaration that I suggest would be the simplest and most efficacious way of looking to the future. And the fact it wasn't done is itself in part responsible for the fact that we've got stuck in a debate about what's this all about anyway.
I mean, I'm wasting everybody's time, but just looking at the list of the agreed list of issues, this is page 120 of the supplemental bundle. If contravention is approved, should the court grant the specific declarations sought at paragraph 55 of the amended particulars of claim? Those are the ones my lord was referring to. And are the claimants entitled to orders for erasure, restriction, and third-party notification?
I obviously accept what you've read. And I do want to go back, if I may, just to deal with the subsequent paragraphs on proportionality. But before I do that, can I say this? The fact that that's what a claimant asks for doesn't mean that that's what a claimant gets. It really doesn't. Indeed, claimants sometimes display a degree of optimism about what the court will give them.
I mean, they often get only some of what they've asked for, but you haven't actually asked for what's now being suggested at all, have you?
I simply make this point, which is this. In the event I persuaded the Court of Appeal that the failure to apply the lump sum principle vitiates the decision, the declaration which I would invite you to make is the one I've described. I can't do better than that. I'm not going to, my lord is entirely fair about criticisms that can be made about the way the case has gone. I accept that. Can I just turn, please, to a few additional points which arise on proportionality? I think I dealt with 93, the point I made about open court, and I had my debate with Lord Justice Warby about the relevance of confidentiality principles in this case. And just for the sake of completion, I should say, I don't accept that approach in confidentiality carries over to data protection.
No, it may be limited to reporting of what happened in the open court proceedings. It may be, you're right, that it's not open season.
No, okay. I'll leave it at that then. 94. Then she says, it's also relevant, this is 94, it's also relevant for me to have regard to the scale of the processing and the impact on the claimants. Although the analysis that led to JS1 plainly involved a large number of individuals, all were claimants or potential claimants in the proposed county court proceedings, they would have been aware that their data was to be closed to the defendant and the proceedings were commenced to court. As for the defendant's disclosure, that was very limited. Well, that's just not accepted. Unless you take the view, which would be open to you to do, that all of this was done and dusted by the learned judge's judgment, what this case is about is what's supposed to happen in respect of all the other cases. And there are many of them, I am told, many. And therefore, with respect, I don't accept that the defendant's disclosure was very limited. It was going to mean their identities were disclosed to numerous people. So that, with respect, is difficult to understand. And then there's a point made about what Ursan should have done. But again, so Ursan should have redacted, but that related to a particular class. I cannot see the defendant can be held responsible for Ursan's failure to take the obvious step. Well, with respect, again, that I'm going to submit is simply irrelevant. The issue here is, has there been an unlawful processing of personal information? What on earth does it matter what the defendants do? That's an obligation that falls on the claimant. Excuse me, put it the other way around. It's got nothing to do with the claimants or their solicitors. It's an obligation that falls on the defendant. And so that's, with respect, completely irrelevant. Then turning to, because I'm afraid I'm going to have to do this slightly. I then look to paragraph 96. They ask what claimants might reasonably have expected to be the consequence of commencing their claims, and only to the court, and subsequently subject to pseudonymization. That's where she refers to it. I do not consider that the interests or fundamental freedoms of the claimant took precedence over the legitimate interests of the defendant insurers in putting in data before the court to support pleas of fundamental dishonesty. That is objectionable on a number of different bases. First, these claimants themselves were not guilty of fundamental dishonesty, and there's never been a holding to that effect. So they haven't sort of, if some word version of volantile non-fit injuria doesn't come into play at all. That's the first thing. And second, and this is a constant thread, she says, I do not expect to consider the interests take precedence over the legitimate interests of the defendant's insurers. What's her reasons for that conclusion? None. Again, the core submission in the case, a conclusion stated without any adequate reasoning provided. And that, with respect, and I don't want to be pompous about it, but is a fundamental part of the judicial role, is to give adequate reasons so that people know the reasons why they've lost and can assess whether...
I'm afraid I don't really follow this, because the reasoning is not just to be found in that paragraph. She has been going through, you may say she's wrong, but she has explained why, she's talked about how claimants might reasonably have expected
I dealt with that.
Material to be available. She's talked about the limited scope of the processing, and then she says she doesn't think that the claimant's interests take precedence over the legitimate interests of the insurer clients.
Yes.
Well, I mean, did she need to explain the legitimate interests of the insurer clients?
But the fundamental submission that I make throughout about all these paragraphs is the absence of adequate reasons. Because it's just not good enough to say, well, the fact that people brought claims meant it was open season for the rest of their life. That can't possibly be right. And if you thought that was right, then you should explain why. And she hasn't. And the second one she gave, forgive me, I think I've forgotten what the point that my lord made to me. I'm not saying that you can't...
She's picking up the points she's already had.
Okay, I'm content to accept that, but what I would, with respect, submit is that taking them cumulatively, and of course you have to take all the reasons together. In our respectful submission, we're dealing here with more with stated conclusions than we are dealing with a reasoning process which identifies what underpins the conclusion. And that, in other words, the complaint is there's no root, but simply a result. I'm sorry if I've taken too long. I've had a long day already. Thank you. And unless there's anything else.
Can I just ask one, just on a point of fact, because you took us very early on to what the judge had said about the schedule, and it may be that you can help us on, I'm not sure, but I'd had a look, sorry, I should of course, the spreadsheet.
Yeah.
I wanted to just make sure that I'd understood properly just what information it does contain. I've extracted it because I found it rather difficult to read sideways in the bundle.
Yes.
And I've tried to understand what it has in it. It didn't seem to me to have any substantive health data in it. It has information about whether there's been a reference to a psychiatrist, I think it's a psychiatrist, the names of the experts, the date of the examination, the date of the report, and whether a particular phrase was used in the report. But it seemed to me that the actual amount of information about health was relatively limited, and that this is relevant to the points you've just been making. That's why I raised it. Am I wrong about that?
Well, the fact, well, you're wrong in this respect. I mean, obviously, what you've read, I'm not going to quibble with.
Well, I may have I'll just make sure I haven't misunderstood it.
No, but I think the position is this, is that would be, inquiries about what doctors have said is clearly, with respect, health.
Yes, yes it is.
And people are entitled under the data protection scheme, if I might call it that, to expect that information not to be made publicly available.
Yes, it's really this range, extent, depth, intensity, and all the rest of it that I'm concerned with. I mean, if one put into the public domain, or even into a piece of litigation, the full psychiatric report containing their full history and all the intimate details that the patient had confided to the psychiatrist, that would be one thing. At the other end of the scale might be they went to a psychiatrist and the conclusion was that they had suffered PTSD. That may be at the more minimal end of the scale of what you could disclose. And I'm just wondering whether I'm right to think that this is more towards that end of the scale.
With respect, I accept that it is towards that end of the scale. But there is a fundamental point which I make and have made already. What is the benefit for the purpose of the litigation in identifying the individual? There's none. You could do that by saying it's Mr. A or Mr. B. You could pseudonymize. I mean, what I'm struggling to understand about the judgment is what is the benefit to the defendants from having the names of the three claimants? And with respect, there isn't. The main information is the information. It's worth what it is. It may be, as Lord Justice Warby might be implying, ultimately not take the case very far in terms of fundamental dishonesty. It may not. I don't know.
Well, with respect, sorry, go on.
No, you go. I think the point of this schedule is to show a pattern. It's not the individual data taken individually that proves anything at all. And as you pointed out, there's been no finding of fundamental dishonesty, and the judge didn't proceed on the basis that every single one of these people, let alone these three claimants, were guilty or had been found guilty of fundamental dishonesty. The point about the schedule is that you may be able to derive patterns indicative of or supportive of a conclusion that in one or more cases there has been fundamental dishonesty.
With respect, my lord, I don't disagree with any of that. But what I do absolutely submit is the position isn't taken further forward by naming the individuals in question.
Yeah.
But this I don't quite follow, because you say the judge had to look at the position as it was before her. Well, she isn't saying it's going to be all right to use all the names in the schedule for the future. She says it was all right to use them in the past, and now there's been pseudonymization. She doesn't say, you can do what you like for the future.
I'm afraid I disagree.
Well, where does she say that you can do what you like for the future?
She doesn't have to. It's what she doesn't say. It's the dog that didn't bark.
Well, she says after the information had been filed, it was possible to agree an
So
alternative
where are
way
you
of-
reading from?
Sorry, paragraph 91, last sentence again. After the information had been filed, it was possible to agree an alternative way of presenting the data. Before that initial step, I'm satisfied that the processing was necessary. So she's dealing with the past. She says, understand how we got there. She's not saying, as I understand it, you can go on regardless. So if you do say that that's what she's saying, where does she say it?
Well, with respect, she doesn't grasp the nettle of the case. And to say that, I mean, we wouldn't be here and we wouldn't have seen the range of submissions which the Court of Appeal has had if the position was as clear as a pikestaff. And it is, expect me, incumbent on a judge to spell out where they've ended up. And that simply hasn't happened. That maybe some of that confusion may be attributable to over-enthusiasm from the parties. That may be true, but a judgment has to spell out what it follows, and it simply doesn't do that.
I mean, just pursuing the same point a moment longer. Again, end of paragraph 109.
So I'm going to have to look at the judgment. Then
Yes.
Give me a minute, please. I think 109 is about in
End
relation
of
to a different
paragraph
issue.
109.
But it's in relation to a different issue, is it not?
But it's the same theme. I'm satisfied that at the point that an alternative means was identified, such that the data subject could be identified by alternative means, the data duly pseudonymized. So she's not saying, you know, forget all about it. Pseudonymization was never necessary and is irrelevant. She's saying it's been done.
Well, but it hasn't been done. I mean, the fact is there seems to be complete confusion on both sides. Because on one side, they say no steps have been taken to synonymize anything. And with respect, if there's no reason why that point couldn't have been made clear by the defendants, whose obligation it is because they're the one who are purporting to breach the data protection regime. That's the first thing. And the second thing is the defendant, and we've gone through this, but the defendants have raised a number of points which go to indicate that these proceedings are fundamentally inappropriate. And what is one supposed to think in that? I mean, maybe to protect costs, who knows what it was there for. But the point is there's a lack of certainty. And to the extent that it's important that a judgment achieves certainty to the parties, with respect, it appears that hasn't done. That's the best answer I can give, I'm afraid.
Thank you very much.
Thank you.
Ms. Hopkins.
My lords, my lady, I'm grateful. It's 20 to 1. I will make as much headway as I can and will, of course, take my lead from the court as to areas on which I should be brisker or spend more time. Could I start, please, with the question that my Lord Justice Warby posed early this morning? Why are we here? What is all of this for? We've heard at some length from my learned friend, Mr. Clayton, about there being confusion on both sides as to what's going on with this pseudonymized spreadsheet, why the defendant has never made clear what its position is. That is simply wrong. We don't accept it at all. Let me just give you an illustration, please. If you have the supplemental bundle, I'll take you to page 55. This is within the closing oral submissions at trial below. I'll give you a moment to turn that page up. And let me just set in context the passage. It's me making the submissions here that I'm going to take you to. It's page 55 of the supplemental bundle.
Thank you so much.
So these are my submissions. Let me set them in context. Prior to skeletons being exchanged at trial, we, the defendants, were certainly not clear that this was a case about pseudonymization or not of the spreadsheet. Extensive raft of data protection points taken in the pleadings, no reference to pseudonymization. Skeleton is served, trial begins, and pseudonymization is very much now the focus. I made various points in my opening submissions about what was and was not pleaded, and also about the puzzling feature of the case as we saw it, which was exactly this. if it really is about forward-looking pseudonymization, it makes no sense because we've already done that. Now, Mr. Clayton says we've never made that point clear. If I could just take you to the section on page 55. These are my closing submissions. At the first hole punch, I say I also addressed the court in opening about what was and was not pleaded. And I make the point there that there is no hint by now between letters D and E. No hint in either the pleadings or in the remedy that what the claimants really wants is an order to the effect that will you continue to use JS1 in the RTA proceedings, but on a pseudonymized basis. I said it's impossible to glean from the pleaded case that that is anything that these to do with the relief that the claimants sought. And then, if I could just ask you to read the "in any event it would be baffling" paragraph. I say the same applies as matters stand today. And we have been very clear that it's the pseudonymized spreadsheet that was used from the order, the time of the backhouse order onwards. We do not accept, I'm afraid, that the claimant's claim was ever really about that. Make no bones about that. It's not. It's not that we think it was lost in the haze of pleading. We simply don't accept that their claim was ever actually about that in the first place. And one indicator, as we say there, is it doesn't make sense to commence High Court proceedings 6 months after the pseudonymized spreadsheet had already been served in the RTA proceedings pursuant to the backhouse order. And now I think part of Mr. Clayton's answer to that, so far as I understand it, is a suggestion. In fact, it's more than that. It's a concrete assertion in paragraphs 15 and 72 of his skeleton argument, in any event, that the backhouse order, which makes provision for the pseudonymized spreadsheet, he says, well, it only applies to those 5 claims. So it doesn't provide us, the appellants, these 3 appellants, with the protection that they say they seek in respect of the remaining RTA claims. That is not sustainable as a characterization of the backhouse order. I think Mr. Clayton showed it to you, but it's the order itself is if we're still in the supplemental bundle, it's at page 220. And once you've turned that up, to point out first the undertaking that's at the bottom, hole punch. You've seen reference to that in the judgment. That's Ersan's undertaking, that they would make no further attempts to debar reliance on Stevens 1. Then the order, paragraph 1, makes clear, paragraph 1, if I ask you to read that, is effectively an all cases paragraph. We express reference to all other claims in which Ersan and Co. act on behalf of claimants. I say that frames what goes on in the rest of these paragraphs, and that's the all claims, all Ersan claims.
Sorry, I was taking some time to get there because my supplementary bundle is in 2 parts and I was in the wrong bit.
So
which page are we at?
220 of the supplementary
Thank you very
bundle.
much. Yep.
And what I showed the court was the undertaking, that's the second hole punch, or if you're electronic, about 2/3 of the way down. And then my submission was that paragraph 1 of that order is expressly an all Ersan claims provision, which I say on any natural reading carries through to the rest of the order. And paragraph 4 over the page is the provision for the pseudonymized spreadsheet. So I say on its face, it's an order of general application before the Central London County Court, which is consistently occupied by endless applications about how to case manage the full raft of Ersan claims. So that's the first aspect of my submissions.
You're leaving the order, are you?
The point I wanted to take from the order was that paragraph 4.
Yeah, no, I followed that.
Yes.
Just looking on again, if you look later in the order, it doesn't seem to be restricted to the 5 particular cases. So paragraphs 8, 9, 10 seem to be more general.
Exactly. That's the point, the contextual point I was just making was the court being concerned with the case management of a raft of URSAM claims. So I say on the face of it, the order doesn't make sense, can't sensibly be read, and we don't accept that URSAM will have read it as applying only to the limited number of cases in respect of which that specific order was made. So that's the first point about the order itself.
And I'm sorry to interrupt, do we have a copy of the schedule that's referred in paragraph 1 of the order? A schedule of all the cases to which this paragraph applies.
I'm not sure we have. I'm not sure we have it in this bundle, but certainly it exists and the parties had it. I will be corrected, I think, by those behind me if we do have it in the bundle, but I'm not sure we have schedules themselves. But to continue the point about what this order means, what its scope is, if I could take you to the exchange before Her Honour Judge Backhouse itself, where this exact point was discussed prior to the drafting of this order. And that's at Supplemental Bundle, page 234. And this, just to tell you where we are here, what this is an extract from. This is, we have in the bundle the order made by Her Honour Judge Backhouse. I've just shown you that. We've got the judgment, which gave rise to that order, and I'll show you something about that in a few moments. This is the exchange at the end of the hearing before Her Honour Judge Backhouse, where consequentials, who's going to do the order, what should it say, all that kind of thing, arises in the usual way. If I could ask you to go over to page 234, this is the transcript from that exchange. Down, if you're using hard copies, bottom whole page. If you're not, 2/3 of the way down, you see a Mr. Coulter, yes, can I confirm? This is my stupidity, I'm sure. That section. Mr. Coulter is representing the URSAM claimants. And we're talking here about the directions that are going to be produced pursuant to this hearing. He specifically asks, these directions apply to the 43, and that's all of them, by the way. That's all of the cases that were live and remain live, or just to these 5. And we see the exchange. So the questions repeated. So all of the 43, yes, we're happy to agree they can. Yes, Mr. Page? Yes. The counsel between them expressly raised the point. What does it apply to? All or some? And I'm afraid it's just not open to URSAM and its clients to say that they have been unclear, they don't understand the scope of the Backhouse order and its provision for pseudonymization. What's more, my submission, namely that it is very clear that this was an all cases order, is exactly what the judge below, Mr. Justice Eadie, found. That's at paragraph 102, so we're now back in the core bundle within the judgment that you've seen a number of times. Page 85, within the core bundle, paragraph 102 of the judgment. And to show you specifically where it's effectively halfway through the page, about halfway down the page, there's a paragraph beginning, more generally, once the issue of admissibility had been resolved, and the URSAM claim was returned to the county court, the defendant offered to pseudonymise the data contained within JS1 for all future purposes. And then she adds something that was done before the present proceedings commenced. So that's our judge's finding on the scope of the order, the reality of what was going on with the pseudonymised spreadsheet in any event. And we know that this is how cases have continued to be progressed within the RTA proceedings as they move towards lead claimant trial in October. One indication of that is something Mr. Clayton referred you to, was an order of Her Honour Judge Bloom page 286 of the supplemental bundle, just for your reference, Mr. Clayton referred you to the provision, paragraph 8 in that case. It's the same pseudonymized spreadsheet provision, so it carries itself over into the ongoing litigation. Mr. Clayton said that the judge below, I think he said a number of times, he found it surprising that that order of Her Honour Judge Bloom was somehow omitted from the picture below. In fact, it's expressly referred to by Mrs. Justice Eadie in paragraph 28 of her judgment.
So which order?
So it was. So it's page 286 of the supplemental bundle. It's an
Yes.
order of Her Honour Judge Bloom.
The 17th of October 24.
Exactly. And the point I make is simply that where in paragraph 8 there one sees the same provision. So I say it is beyond doubt that there was somehow a one-off confined backhouse order with one paragraph applying to 5 claims. The reality is the pseudonymized spreadsheet is the only one that is being used. Yes, there has been little actual progress. That's because various tangles and all other claims being stayed. So there isn't anything to progress in those other claims, apart from the ones that are going to trial before His Honour Judge Saunders in October. So it's simply not sustainable to, I say, pretend that the pseudonymization issue is still at large and that the claimants don't understand what's happening with it.
And you just referred, as Mr. Hopkins, to paragraph 26, was it, of the
28 of
28.
the judgment,
Thank you, the judgment.
where express reference is made to the very order that Mr. Clayton repeatedly says he's surprised wasn't referenced. All of this chimes with what Mr. Justice Constable found in refusing permission to appeal in relation to Ursan's attempt to stay the RTA proceedings while these data protection proceedings were resolved. Just to show you the reference to that, if we're in the judgment paragraph, it's in fact the same paragraph I just referred to in answer to your ladyship, paragraph 28 within the judgments of Mrs. Justice Eadie. We see the reference there to the Her Honour Judge Bloom order, we've just talked about that. Then the reference to Mr. Justice Constable's refusal of permission to appeal against Ursan's application to stay proceedings, stay the RTA proceedings behind the data protection claim. That is refused. Permission to appeal is refused, and one sees from that extract from Mr. Justice Constable's judgment that focusing here on the undertaking Ursan gave, he's not concerned here about the spreadsheets. It's not what he's dealing with in the pseudonymization issue. Leave that to one side. He is talking about the undertaking, and he says, with respect say rightly, one can't read the undertaking Ursan gave in the and recorded in the recital to the backhouse order as somehow limited to those particular cases. It was a general undertaking. And so I say that this is yet further support to the general application of the backhouse order.
This is not a determination that's raised judicata between these parties. You're relying on it as just a correct interpretation of what happened.
Correct. That's all I say is what I've submitted about the pseudonymized spreadsheet and its general applicability across the RTA proceedings chimes with what Mr. Justice Constable understood to be the effect of the Ursan undertaking. So that brings us back to the question, what is all this for in practical terms? And I cannot think of a good answer. I can only think of bad ones. We have made no bones about the fact that we say all of this is part of a campaign to attempt to get around that very undertaking we've just looked at, to get around the admissibility issue of JS1 that's been conclusively resolved, and that the court should see it for what it is. So that's one theme I wanted to start with. Pseudonymization, I think the court has got this, I detect from submissions, from exchanges this morning, but just to make very clear, pseudonymization does not feature in the particulars of claim. Slightly puzzling exchange where Mr. Clayton took the court to the particulars of claim and said pseudonymization does appear. Like Mr. Justice Warby, I have never been able to find that word, and I've had to look at these pleadings a lot more than the bench has. It simply doesn't appear, either as a matter of pleaded ground of contravention, or in the remedies section. And my Lord Justice Warby looked at that. There is simply nothing one could extract from the claim, the way the claim is put, to give any hint that this was a claim about pseudonymizing a spreadsheet. Really, it was a full frontal attack on the principle. The principle, as advanced against us in the pleaded case, was it is wrong under data protection law to use the personal data of one claimant in furthering your case against some other claimant in a claim to which you're not a party. And then that was unpacked by reference to various data protection complaints. The question of why was the JS1 spreadsheet not pseudonymized from the outset, so why were names included? I think the court has this point. It's expressly recorded. Let's stick with the judgment rather than turning up the Stevens witness statements if we need to, but the court will recall it's the second Stevens witness statement that explains specifically why names were required at the outset of the exercise. So paragraph 18 of the judgment records the relevant extract from JS2. One sees 52E and then 58. The short point, so that, well, we have to use names in the first place because we don't have individual identifiers of any other kind. We have a case reference that applies to an accident, not an individual. So that's why we don't have any other cipher on our internal systems, so we use names. And then the paragraph 58 point is that, well, we did do one previous exercise whereby we presented Ursan with simply the fruits of analysis, and they complained that they weren't able to interrogate and understand that. Just to, if it helps to see where that features in JS2. JS2 is in the supplemental bundle. And it's 52E, the paragraph we've just looked at, comes at page 268. We're sitting here under a heading, the relevance of the fields in the data set. You'll see what Mr. Stevens does in the second witness statement is explain for every field in that spreadsheet that we looked at briefly, why does that field appear? What's its utility and justification? E is the name of claimant column. You've seen Mrs. Justice Eady refer specifically to that. I was taking you to the second relevant extract, which comes at 58, but it might be...
So there are 2 points here. One could be met, couldn't it, by inventing some other cipher, A, B, C, or BB, and all the rest of it, in place of a name. The second point is that it would make it more difficult, I think, for the claimant solicitor to verify the accuracy of the data.
Yes.
So they wouldn't be able to use that sort of cipher to link the data with the individual.
Yes,
Yeah.
and as we see, if we go now forward to page 278, points are linked. Page 278, you see under the heading in JS2, serving the evidence without the supporting data. See, Mr. Stevens says at 54 to 56. We did do effectively an anonymous version, anonymous cut of this, and Ursan come back saying, well, we need to understand the specific data itself so we can interrogate it.
Sorry, where do I find that?
So 54 to 56 is the previous smaller similar facts exercise that Mr. Stevens summarizes.
Yeah.
He says, well, and at 58 he makes the point that Ursan then asked, well, who is it? We can't make sense of this statistical small sample data. Your observations need to be interrogated by reference to the data we're actually looking at. So give it to us, please. So he provides the justification for why names were used up to a certain point. I will finish on one point, which is why did things change? I think the court has this point. It's when matters surface before Her Honour Judge Backhouse. These are the proceedings we've already looked at. Mrs. Justice Eadie refers to this at her paragraph 25. But if we could just turn up briefly the point here so that we can get the picture on why pseudonymization is introduced. Supplementary bundle 223. Apologies for jumping you between bundles. This is the judgment of Her Honour Judge Backhouse, the one that gives rise to the order we've looked at. If we go to paragraph 11 to 13, set out what the range of applications before the court there were. While in passing, paragraph 22, Her Honour Judge Backhouse notes that it's regrettable that Ursans haven't actually engaged with the substance. Paragraph 24, she notes her concern about how all of this is being funded. It's a question that has bedeviled these proceedings for some time. But if we go forward to paragraph 47, it's 47 to 49. Now, let me just tell you what's going on here. One of the applications before the court in these particular proceedings was what was called a disclosure application. And one sees the characterization of that application, paragraphs 47 to 48. I'll leave you to consider that. But it's asking for more information, asking for the ability to interrogate how do we understand the data in JS1 in that spreadsheet. And it's at 49 where Her Honour Judge Backhouse refers to it in these terms. The second glimmer of cooperation is that the defendants have offered to provide a revised schedule containing Ursan's reference number for each claimant. And so one sees that this pseudonymization mechanism, it actually arises as a sort of pragmatic compromise so that Ursan can more easily interrogate and understand the data that's in JS1. So it doesn't emerge as some kind of data protection mea culpa. That's not its genesis. And there's good reason for that, because let's just remember, it's easy to get lost in the weeds of all of this. There had been a data protection challenge when the admissibility of JS1 was attacked by Ursan. We've seen reference to this in the judgment. The data protection challenge was effectively abandoned by Mr. Koppel pursuing the case on behalf of the claimants there. It fell away. So the data protection issue, as far as it surfaced, had simply been cast to one side by Ursan and their legal team's own choice. One also, as we'll see this when we turn to the judgment after the adjournment, the Information Commissioner had received a complaint from Ursan about the use of their client's data in JS1, and the Information Commissioner had said no contravention discernible to him. So data protection issues had gone silent. Ongoing applications about managing the litigation, how do Ursan get to grips with the JS1 spreadsheet, interrogate it properly, and so on. And that's where we give, that's what ultimately in practice produces the pseudonymized spreadsheet. But be that as it may, you've got my point, that's where I started this morning, that from that point onwards, it's only ever been effectively locked in as the document that's being used. So I'll pause there after the adjournment and make some points on the correct legal approach, and then a brief walk through the judgment and what I say to Sam.
Thank you very much. So 2 o'clock.